Okay, sorry, we're having a little bit of technical difficulties here. And then surreptitious intrusion against a minor under the age of 18, well, with somebody more than 36 months older with sexual intent. That now requires registration, has for a few years now. Criminal abuse. So if a caregiver or facility staff person engages in sexual contact or penetration with a client under circumstances other than the other criminal sexual conduct statutes that require registration. And again, we don't see that a lot, but that does require registration. False imprisonment, and that's all false imprisonment. Solicitation, inducement, or promotion of the prostitution of a minor or engaging in sex trafficking of a minor under 18. And then when you get into kind of this group of statutes that we're going to be talking about, the ages vary for the different offenses. So this one is under 18, but engaging in hiring or agreeing to hire a minor under the age of 14 for prostitution, that's 14, and that was 13, and that recently changed to 14. And I think at one time that was 16 or 18, yeah. Soliciting a minor under the age of 16 to engage in sexual conduct, using a minor under 18 in a sexual performance, possessing a pornographic work involving a minor under 18, and then if the person was sentenced as a pattern sex offender, that requires registration. And then we have provisions in our statute to cover federal and state law. So this provision is charged with petition for, including court-martial, violating a law of the United States, including the Uniform Code of Military Justice. And again, so this is new language, similar to an offense or involving similar circumstances to an offense, and then described in the other offenses I just described, and then convicted of or adjudicated guilty for that offense or another offense arising out of the same set of circumstances. And what the general idea with the federal offenses and the offenders from other states is, at least when they were, initially included, when the legislature initially included those, the general idea was that if somebody has to register here, then somebody coming here on a federal offense or coming from another state should have to register kind of in the same situation or for the same type of offense or similar type of offense. So that's kind of what this language is getting at, and historically what it's been trying to get at. And then, so this is the other state language. So same kind of thing, charged with petition for another state, similar circumstances, to an offense described and convicted of that or another offense arising out of the same set of circumstances. Now, with the out-of-state offenders, and is this the federal offenders too, where it has to be 14 days? We just do that wrong. Okay, so with the federal offenders and the out-of-state offenders, there's this additional requirement that they enter the state to reside, work, or attend school, or they enter the state and remain for 14 days or longer. And then the other thing is if they're in the state for an aggregate period of time over 30 years. So it might not be 14 years straight, but if they come for 3 days and then they come for 3 days and a couple of weeks and 3 days and a couple of weeks, and over the course, let's say they work regularly in the state, so they're here for more than 30 days over the course of the year, then that counts for an out-of-state requirement to register. And then the other thing that we look at for, BCA looks at for out-of-state offenders is 10 years have not elapsed since release from confinement. And then if they were never confined, they look at the conviction or adjudication date for that 10 years to see if it applies. And then there's this other provision, if the person is subject to longer registration in the other state or lifetime registration, they're to register for that time period, regardless of when they were released from confinement, convicted, or adjudicated delinquent. And again, my understanding is that the reasoning for this kind of language is that to prevent, I guess, what you would call maybe forum shopping or somebody coming to Minnesota just because they can get out of registration kind of thing. Uh-oh. No, okay. Okay. I did. Oh. Oops. Okay. Oh, and this is another area that I work in, so it's not part of this group, but this is another one that requires registration. If the person was committed as a sexually dangerous person or sexual psychopathic personality, or a similar type of commitment federally or in another state, then they have to register, and that's regardless of whether they're convicted of any offense. And then there's an MIND provision, and that requires that the person be charged with or petitioned for a felony violation. So any of the offenses listed are a similar offense in another state or the United States. And then there are 3 steps to the MIND, or mentally ill and dangerous part. First, they have to have the requisite charges, and then they have to be found not guilty by reason of mental illness or mental deficiency, or found guilty but mentally ill after a trial for that offense. And then finally, they have to have been committed as mentally ill and dangerous. So we look at all 3, if we're looking at whether somebody has to register under as mentally ill and dangerous committed person, they have to meet all 3 of those criteria. So then there's Minnesota Statute 243-167, and that's with respect to crimes against the person offenses. And that is a statute that literally, I think almost it's mostly a list of statutes. So I tried to break those out a little bit in this presentation. So what that provides, that in addition to the requirements under the regular registration statute, the person has to register if they're later convicted of a crime against the person and either weren't ever required to register for an offense that now would require registration, or if they've already finished a term of registration, then they would have to start registering again if they have a crimes against the person conviction. That's accurate, right? Oops, oh, sorry. Okay, so because this, like I said, the statute lists primarily numbers in 243-167, I broke those out here. So these are the crimes against the person offenses. Illegal possession of firearms, 1st or 3rd degree murder, 1st and 2nd degree manslaughter, 1st through 4th degree assault, gross misdemeanor or felony 5th degree or domestic assault by strangulation, use of drugs to injury or facilitate a crime. I think it's to injure. 1st degree egg robbery, kidnapping, false imprisonment, gross misdemeanor 5th degree criminal sexual conduct, 1st degree tampering with a witness, 1st degree burglary, gross misdemeanor indecent exposure, felony crime committed for the benefit of a gang, felony malicious punishment of a child, felony harassment, stalking, and felony possession of firearms when ineligible. And again, like a statute like the felony possession of firearms are all kinds of reasons people are ineligible under that statute. So there's a whole nother analysis on when that applies. Let's see here. So I also put in here kind of some of the general things, and Katie will talk more specifically about from an administrative standpoint how this works. But so once somebody is convicted of the requisite offense or adjudicated guilty for the requisite offense, The statute provides for the court to tell the person of that duty to register and to provide people who are convicted with registration notification forms. I'm sorry, the notification forms are to notify them of the requirement to register. The court may not modify the duty to register in the pronounced sentence or disposition order, and our statute specifically provides that. The court is to make notification forms, complaints, and any sentencing documents available to the BCA for the BCA to make sure, you know, they're following their obligation to administer the registry properly and make sure that convictions apply under the statute. And then the statute goes on to kind of try to cover situations where the court doesn't, for whatever reason, notify somebody of the requirement under the statute. So if the court doesn't notify somebody at sentencing, then the assigned corrections agent is required to notify the person of the registration requirements. And if a person doesn't have an assigned corrections agent, then law enforcement with jurisdiction over the person's primary address is supposed to notify the person of the registration requirements. And when a person's committed as a sexually dangerous person, a sexual psychopathic personality, or mentally ill and dangerous, when they're released from that commitment facility, then the facility itself is required to notify the person of the registration requirements and obtain that registration information and provide that to the Bureau of Criminal Apprehension. And then the statute has the criminal provisions provide that it's a crime for someone who was given notice, knows, or reasonably should know of the duty to register, to knowingly commit an act or fail to fulfill a requirement that violates any provision of the statute, or to intentionally provide false information to a corrections agent, law enforcement, or the BCA. And under the penalty provisions, a conviction carries a mandatory sentence of 1 year and a day in prison, but the prosecutor may file a motion to have the person sentenced without regard to the mandatory minimum, or the court may actually sentence without regard to it. So I'm not sure how often people actually get that 1 year and a day sentence. I don't think it happens very often, but I don't know exactly what the numbers are on that. And if a person's a risk level 3 offender at the time of the crime and is sentenced to prison, then there's a 10-year period of conditional release that applies. So when they're sentenced for that offense, the court's supposed to inform them of their 10 years of conditional release. So generally, then there's a provision of the statute that talks about the terms of the registration. Generally, the term is 10 years from the time the person initially registers in connection with the offense, or until probation, supervised release, or conditional release expires, whichever of those occurs later. If a person's committed as either mentally ill and dangerous or SDP or SPP, those 10 years don't include the time of their commitment, because otherwise somebody might be committed for the whole time of the registration period. And the idea is to be tracking them in the community. If a person fails to register, 5 years may be added to the end of that registration period. From a practical standpoint, it's my understanding that that's something that's not added on unless there's actually a conviction for failure to register. Even though the statute gives the BCA probably some broader ability to do that, they do not do it without a conviction, is my understanding. And Katie can correct me if that's wrong. If the person's incarcerated for a new conviction or revocation of probation or release, then the person shall continue to register for 10 years from the last release from incarceration. And then there are provisions for when a person is required to register for life. So they're required to register for life if they have a registration offense or they commit a registration offense or convicted of a registration offense, and they have a prior conviction or adjudication for an offense. That requires lifetime registration. If they're required to register based on a conviction or delinquency adjudication for murder while committing a criminal sexual conduct, that first one I talked about, that murder conviction, that requires lifetime registration. If they're required to register for more serious paragraphs of 1st through 4th degree criminal sexual conduct, and again, this lists various paragraphs of that statute. It's essentially with the young victims, the very young victims, like the under 12 victims, and if there's violence and weapons used, those are the kinds of offenses that require the lifetime registration under the crim sex statutes. And then if they were committed as SDP or SPP, that requires lifetime registration. And again, this is it's another part of the statute that says if a person's required to register under the laws of the state in which they were previously convicted or adjudicated, they shall register for that time period required by the state of conviction if it's longer there than here. So I put in a little bit of information on the cases that we generally look at with respect to the same set of circumstances language in our statute, just to give you an idea kind of how we apply that or the things we look at for those. So the Lopez case was actually the first, and well, Fountain was the first same set of circumstances case, but it didn't go into that much of an analysis on what you look at. So Lopez is probably the one that we look at the most on that issue. And just to give you a little idea of what happened in that case, they were charged with aiding and abetting kidnapping and aiding and abetting first-degree controlled substance crime. And they pled guilty to the controlled substance charges, and the prosecution dismissed the kidnapping charges. And from a date standpoint, what happened is on April 3rd and 6th, a confidential informant purchased meth from the defendants. On April 6th, one of the defendants gave the informant additional meth to be paid for at a later date. Then on April 16th, so 10 days later, they approached him, said they needed the money, and basically that's when the kidnapping occurred. So in that case, our Supreme Court said that was not same set of circumstances. And if you look at a big thing with this is the dates, but there were also different people involved. So the general language that came out of that opinion is that the same set of circumstances requires registration where the same general group of facts gives rise to both offenses. And they look at whether they overlap with regard to time, locations, persons involved, and basic facts. And so they basically said the drug sale was complete on the 6th, the kidnapping was related, but it wasn't same set of circumstances. And they looked at that it involved different people, slightly different people, and it occurred in a different place. So then very recently, earlier this year, State versus Berry came out. And in that case, Berry was convicted of aiding an offender to avoid arrest out of the same set of circumstances as aiding the commission of kidnapping and false imprisonment. And in her case, her husband had committed the kidnapping and false imprisonment. She had driven him there, and later on, she had driven him from the scene, but then later on, they had left a hotel and fled. So there was a little bit of a time change with respect to when the fleeing took place, or I'm sorry, the aiding an offender took place. So the Supreme Court found in that case that that was not same set of circumstances. And they basically reiterated that the Lopez factors are the ones that apply. Time, location, persons involved, basic facts should be considered, and emphasized that the Lopez factors should be applied narrowly. So Lopez is still the main, those are still the main factors we look at with the additional guidance to apply them narrowly. And then I wanted to talk to you some about the federal requirements, because a lot of our statutory requirements historically have come out of the federal requirements. So in the past, and I think still for some states, the feds give pots of money for states that are in compliance with what the feds want in your registration statutes. So I went over, kind of some of the things that they require, and whether I identified a little bit, kind of how whether we're in compliance or how close we are in compliance with these things. So they require an immediate transfer of information. I think we mostly are in compliance with that. As far as the time, the fact that the person has to register is transferred, that information gets to the DCA. The offenses that must be included for registration. So our statute includes most of what the federal government says should be required, but not all of the required offenses. The required information to be provided and updated. Again, we include most, but not all of that. We don't require photo of a driver's license, which the federal requirements ask for. We don't require internet identifiers, digitized copies of passports, professional licensing information, temporary lodging information or dates of travel, aircraft, watercraft, or where vehicles are kept. And those are all things that the federal regulations ask or require to be in compliance with them, if that makes sense. Where somebody is required to register. So where they reside, where they're employed, where they're a student, we're in compliance with that. Initial registration timing and notice requirements, we're in compliance with that. So retroactive classes of offenders, they require, we capture some of those with 243-167, but not all that they require. Verification and appearance requirements, we don't comply with that because that's based on their tier system, and we don't comply with their tier system because we do our risk levels through the community notification statute, and we have a completely different tier system in Minnesota. And then public website requirements. The federal government actually has public website requirements, and we do not make information public in Minnesota except if out of compliance with registration in certain situations. And even then, once somebody's back in compliance, they're immediately off the public website. And then again, with the federal requirements, they have community notification requirements that they require as part of the registration statute, but we handle that under 244-052, not in the registration statute. And to be, 244-052 requires that statute be applied in that process for offenders required to register who are released from prison. So it only applies in that context, and for certain offenders who come in from other states or who are supervised in Minnesota. So it doesn't apply to all registered offenders, or really even close to all registered offenders. Failure to register criminal penalties, we comply with the requirement that the maximum imprisonment be over 1 year. But like I said earlier, we have prosecutors can ask for that to be waived, courts can waive that, but we do have that requirement in our statute. And more details on those federal requirements can be found at the DOJ SMART website. And so I guess I just would generally note that many of our offenses, or at least some of them, including some of the juvenile requirements, do trace back to those federal requirements. And that is something where there can be penalties imposed on states for not complying. I think from my understanding, we've been able to recoup those when we've been penalized, but that is just so you know, some of the history traces back to those federal requirements. And that's all I have. I don't know if anyone has any questions right now. But otherwise, there's my email. And if people do have questions, I think Olivia asked that you email the whole group if you email me with a question, just so that I can answer in case the whole group is interested. And otherwise, I'll turn it over to Katie.
Oh, and if DOC could oversee who's raising hands, that would be helpful.
So
Looks like Kelly.
Representative Moeller.
Yeah, thank you, Mark. And I just want to thank everybody too for being here. I also saw Representative O'Neill and Senator Ingebrigtsen on this too. And I have a question for Angie and a question for Mark. Also, just a fun fact for Angie, I used to work with her years ago, and she wears a purple suit whenever the Vikings win. So Angie, I hope your suits aren't going to be collecting dust this season. Big Vikings fan. I had a question about the 10-year period for registration, and I'm curious about what applies to juveniles versus adults. It's my understanding from the group that the CSC working group did that they were really interested in looking especially at juvenile offenders. And when you talked about convictions, were you also talking about those who were adjudicated delinquent, and do the same timelines apply?
Yes, the same timelines apply to juveniles.
Okay, great, thank you. And then
Oh, wait.
Oh.
This is Katie talking.
We can't hear.
Oh. Sorry.
The one piece on the lifetime registration for juveniles is that they have to have a second conviction for those CSC convictions. It's not the first time offense for juveniles. Juveniles first time offenses only for murder 1 clause 2 and SDP SPP commitments. Otherwise, they have to be a repeat to hit the lifetime and have to have them committed after 8/1/2000.
Okay, yeah, thanks for that clarification. I'm guessing the group is going to want to discuss juveniles at some point. I do have a question for Mark too, and that's, I wasn't part of the working group legislators. We weren't actually on the CSC working group. We were following that work. And so I do recognize here many of the people who are participating in that. But there's a lot of people on the call I don't know that are also in the group. And I don't know at some point if we're going to go through and have introductions. Okay, great. Just want to make sure that we do that at some point. And doesn't matter to me when that is, just wanted that. So thank you so much. That's all I have.
Okay.
I would just like to say for the record that I have some fabulous Vikings leggings that I can wear when I work remotely now on the day after Viking victories. But if I do make it into the office, I will wear some kind of business casual purple on Mondays following Viking victories. All right, now I'm going to turn it over to Katie. Thanks,
well, actually, what we're going to do right now, and that was Representative Moeller anticipated exactly what we're going to do. At this point, I think all the work group members are in the meeting now, and most of the public observers are here. So this is the good time to do those introductions of the work group members. And I will start this out with by first name alphabetical. So that would starting with Andrea.
Hi, good morning. Can you hear me? My name is Great. My name is Andrea Leeser. I am an assistant county attorney in Brown County, and I am happy to be a part of this work group.
Okay. And actually next, let's go back to Angie just to make sure everybody knows your title.
I'm an assistant attorney general, and I already, when I did my presentation, I said what I do, but I'm the leader of the civil sex offender unit at the Attorney General's office.
And next will be Brian Heinsohn.
Good morning. I'm Brian Heinzone. I'm a supervisor in the Risk Assessment Community Notification Unit. I supervise the 5 psychologists in our unit. Been with the department for 23 years and been a part of the Risk Assessment Community Notification Unit since 2004, dealing with registration community notification issues. So glad to be a part of the group. Good morning.
Okay, I am I'm trying to find Janine here. Do we still have Janine?
I'm here, Mark.
Okay, thank you.
Hi, I'm Janine Hebert. I'm the Executive Clinical Director at MSOP at the Department of Human Services. And prior to that professional chapter, I worked in the Department of Corrections, and I'm happy to be here and super excited with the makeup of this group.
Okay, then next we have Jeremy Cassette.
Good morning, everybody. I'm Jeremy Cassette. I am the administrative lieutenant for the White Earth Tribal Police Department, located just north of Detroit Lakes. Happy to be here.
And then next, Jim Fleming.
I'm Jim Fleming. I'm the district public defender in the 2nd Judicial District, which is Ramsey County, St. Paul. I was also a member of the criminal sexual conduct work group, and I was also on that same steering committee.
Okay. Then next is Josh Florell from the BCA.
Hi, Josh Florell. I'm a special agent in charge of the predatory crime section here at the Bureau. I've been special agent in charge and assistant special agent in charge for quite a few years. Thanks.
Okay, then I have Karen Jaszewski.
Good morning. Yes, I'm Karen Kompa-Jaszewski. That is a mouthful. I'm in the Legal Counsel Division at State Court Administration. I'm here as the Judicial Branch representative, and my work primarily focuses on criminal case processing. Thanks.
And then back to Olivia here with Katie. Whoops. Let's get you unmuted.
Hi, I'm Katie Myers. I'm the program administrator for the Predatory Offender Registry here. I've been with the BCA for about 21 years.
Okay, and next we have Katrina.
Katrina Dexter, Director of Juvenile Justice Reform at the Department of Corrections.
Okay, and then Representative Moeller. Once again.
There we go. Yep. Yeah, Representative Kelly Moeller. I represent District 42A, Shoreview, Arden Hills, Mounts View, and really happy to be here. Thank you.
Okay, and then Linda Sloan.
Good morning, Linda Sloan, and I'm the Executive Director for the Council for Minnesotans of African Heritage. Looking forward to working with each of you.
Okay. Then Chief Mike Tuskin.
Hi, my name is Mike Tuskin. I serve as the police chief for the city of Duluth, and I'm also a representative of the Minnesota Chiefs Association. Thank you.
Okay, and then Nate Reitz.
Hi, I'm Nate Reitz. I'm the executive director of the Minnesota Sentencing Guidelines Commission. I was also on the outcomes subcommittee of the CrimSex task force, which kind of morphed into this issue. Basically, they really didn't want to talk much about outcomes, and they wanted to talk about predatory offender registration. So that's, I think, why this group exists.
Okay, and then Nicole Matthews.
Good morning, everyone. Nicole Matthews. I'm the Executive Director of the Minnesota Indian Women Sexual Assault Coalition, and I'm a descendant of the White Earth Band of Ojibwe.
And then we have Patty Wetterling.
Good morning. I'm Patty Wetterling. We're currently camping up in Grand Marais, so I can stay on the call till 10:30. I've been involved with sex offender registries since 91. Well, we started looking at it in 89. And most recently, I serve on the board for the National Center for Missing and Exploited Children. And we had a committee on children with problematic sexual behaviors and trying to get them off the registry. So I have a huge concern for children and how we're treating those situations. I'm so honored to be with all of you. I'll be more formal next time.
Okay, then we have Renee Meerkens.
Yes, good morning, everybody. I'm Renee Merkins. I'm with Hennepin County Community Corrections and Rehabilitation, representing the 3 delivery systems, CPO, DOC, and MACAC. I also was involved in the CSC reform work groups where we had that discussion about predatory offender registration, hence the reason for this committee.
And then we have Sherry Schultz.
Morning, everyone. I feel I'm a bit of an anomaly on the call. I am a resident of Victoria, Minnesota, and a long-standing HR professional. I currently reside in Minnesota and head up a lot of human capital initiatives for a large automotive group. My focus has always been on human capital analytics, training, and education. And I'm also the mother of a victim. So I am incredibly honored and passionate about being here. So thank you all for having me. And I also worked recently on an amendment to our ordinance in Victoria. So again, I'm honored and thank you all for having me.
Okay, and then next, Stacy Bettison.
Hi, everybody. Stacy Bettison. I'm an attorney and I'm representing the Minnesota Association for Criminal Defense Lawyers. I was also on the CSC work group as well.
And then the final one I have listed here is Sheriff Troy Heck.
Morning, everyone. My name is Troy Heck. I'm the Benton County Sheriff. I also have the pleasure of serving on the CSC Working Group Committee. Looking forward to working with y'all.
Okay.
And I just want to introduce myself as well as the co-lead. I'm Olivia Anderson. I am the lead for BCA on the working group, together with the Department of Corrections. Just a couple of things before we really get started on the actual working group. We have asked that if you guys have questions or concerns, please email both Mark and I. Depending upon the day or the issue, we may need to triage and have that conversation. If there are any questions for presenters, please feel free to raise your hands. If we aren't able to get to you, please send an email out to the whole group. We know that folks will share a lot of the same questions or concerns with the presentations, and so we want to be sure that everybody is getting the answers. And yeah, thank you all for being here.
Yeah, thank you. So keep that in mind. Olivia and I are going to be doing some of that background work, that coordination work behind the scenes here. Again, today, we're not going to have time for the public input or questions. Hopefully we'll have that opportunity at any of the meetings, but do feel free to send an email to both Olivia and myself if you would, if you have any questions, additional information. And again, just to keep things orderly, we want to make sure that the working group members, raise your hand and we'll try to get you recognized, and then you can ask a question at that time. Members of the public, you're just here to observe at this time, but do feel free to send in questions by email. And we'll move on here to Angie.
Katie.
All right. Katie, sorry about that.
So just click that.
Good morning. As I introduced myself earlier, I'm Katie Myers and I oversee the predatory offender program here at the BCA. Been in this role now since 2012, but actually started here back in my student worker days in this actual unit. So I've got the majority of my time here at BCA spent in the POR unit. Today I'm going to just cover some of the registration information now that Angie has gone over who's required to register, what requires registration, just some of the obligations and what the role of the registry is here in relation to predatory offenders, as well as some statistical demographic information that might be beneficial to the group for starters. Understanding there will probably be more questions as to numbers that we have in the registry, but right now we just pulled some starting information for everybody. Oops, now I went one too far. Sorry about that. There we go. Sorry that I have to look away. Actually, I want to try to. There we go. Okay. The registry obligations, by statute, the Bureau is required to immediately investigate any non-compliant offender, specifically those who are civilly committed as sexually dangerous or sexually psychopathic, who are out in the community on a provisional discharge, or any level 3, non-compliant level 3 offender who's out in the community. Our predatory crime section, the agents in that unit would go out and investigate and locate those offenders immediately. The other thing the BCA is responsible for is receiving and maintaining all of the POR documents. Per the statute as cited here, the paperwork is to be completed in person with either law enforcement or a corrections agent if they have one assigned, or with Department of Corrections in a secure facility, one of the prisons, and then immediately, actually, I think they have 2 days to get that paperwork sent to the BCA. The BCA is also required to send verification letters to offenders based on the frequency set by the statute, and also notify law enforcement officials in Minnesota of the offender's primary address changes. So we send notifications to law enforcement jurisdictions in Minnesota of offenders moving in and out of the jurisdictions. And then we also are required to notify other state registries. So every state has a equivalent, mostly sex offender registries, but we notify them of any offender moving in or out of their state. Not necessarily does this mean that the offender is required to register in that state, but we send that notification and they can make their determinations just as we would if an offender moved here. Registration, we're responsible for making registration determinations based on Minnesota statute 243.166. And these, as Angie has stated earlier, these are made in consultation with the Attorney General's office as well. Every out-of-state offender, Angie and I look at together and make, ultimately the BCA makes the determination in consultation with them as to whether or not someone is required to register based on the statute. Information maintained by the BCA in the POR unit is not available to the public except through the non-compliant public website. So all of that information, as Angie had said earlier, when talking about SORNA and federal requirements and a public website, Minnesota doesn't really have a public website because it's displaying only non-compliant offenders on our POR website. The DOC has a different website that displays level 3 offenders, but that is not part of this statute. So for the offenders that are required to register, based on what Angie had covered earlier, what they're required to provide is listed out in subdivision 4A of 243.166. This information includes primary address, secondary address, which includes any property that the offender may own, lease, or rent, their places where they are employed, their, if they're attending school, their school location, their vehicle to include year, make, model, plate, and color of any vehicles that are owned or regularly driven by the offender, the expiration date of the license tabs on the vehicles that they own, all telephone numbers for their work, school, home, and any cellular information. And the offenders are required to provide this information. Their primary address is required to be provided 5 days prior to moving. And then all other information is provided within 5 days of the statute applying. So within 5 days of purchasing that vehicle, 5 days within getting that new job, let's say. And then they're required to immediately notify their corrections agent if they have one, or law enforcement if they don't, once that information no longer applies. And by statute, all of this information is required to be provided in person and requires the offender's signature with that information. So the process for registering, the offender would either complete, if they're sentenced to prison, they'll go in and they'll complete the initial registration form, which will get all of their demographic information, the offense information for which they are registering for, as well as a duty to register, which kind of lays out the statute. We kind of just describe the many points of the statute. I believe we have 26 or 27 line items that don't necessarily apply to every offender, but it's, again, the information within the statute. But this registration form is basically what starts that registration period, especially if they are just sentenced to a probationary period and no period of incarceration. But the form gets completed by their corrections agent, and statute says, immediately upon assignment of the corrections agent, or this gets completed at the intake point often at St. Cloud, I believe. There's a couple intake officers there that we have a relationship with, and I know that they complete them. It could be done at other facilities as well, but that gets done. They'll also, for offenders moving here from out of state, they will complete this information with law enforcement, the local law enforcement in the jurisdiction where they are residing. What the offender is required to do at that initial registration period is they're required to fill out that form, which I've already described. They're also required to provide a DNA sample. They're required to provide a photo and also be fingerprinted. And again, as stated earlier, the statute requires that the person who completes that paperwork send it to the BCA within 2 days. Thereafter registering, anytime an offender has any change to that information that we called out, that work or primary address, work, school, secondary addresses, the vehicles, the phone numbers, all of that information, they're required to provide it on a change of information form, which allows them to update all of that information. Also requires them to do that in person and in writing, done in person and in writing with law enforcement or a corrections agent always. Another piece that the offenders, another document that the Bureau is responsible for maintaining are for the homeless offenders. There's a provision written in the statute that addresses, I think it's 3A, that addresses all homeless offenders or offenders who lack a primary address. They are required to provide where they are going to be located in the next week with as much specificity as possible, so that if law enforcement needed to be in contact with them, they could locate them. Not saying that they're in Ramsey County, but that they're, in the parking lot at 1430 Maryland Avenue. As much specificity as possible is asked for in that. They must also register with local law enforcement within 24 hours of entering that jurisdiction and no longer having that primary address. And then going forward, weekly thereafter, they are required to stop into local law enforcement during business hours and check in with them and complete a homeless check-in form that acknowledges where they're going to be for the following week. If they have a new phone number, they can provide it on that. And then that form is signed off by the offender that they've checked in and that's sent here to the Bureau, so that this provision, a little history on it, back before this provision went into place, and I believe it was 2005. Prior to that, homeless offenders, we couldn't get them their verification letters, which ultimately gives them the ability to see what we have on file here. Now with this provision in place, the Bureau can mail the verification letter to that law enforcement jurisdiction where they are checking in and have them complete that form. A little more on the verification letters. This is yet another statutory requirement of the Bureau, is to send a verification letter to the offender to confirm and show the offender what information we currently have on file. And it's their opportunity to make that correct if they need to. Again, not waiting for this moment, because by statute, they need to do it, within 5 days of the changes. But this is our opportunity to send them the information that is currently on file here at the BCA. They're given 10 days to return that form or are marked non-compliant. With that form, the Bureau provides them with a self-addressed postage paid envelope to return it. So we make it a pretty seamless, easy process. If they open it and fill it out right away and send it in, there should be no problem with that 10-day turnaround. A little more information on those verification letters. We have 2 frequencies. We used to have 3. We used to have to send quarterly to the civilly committed offenders, but a couple of years ago, that was switched at the legislature to go just semi-annually, and that stayed within the federal guidelines. Federal guidelines require those civilly committed offenders to receive them twice a year. The other people that receive them twice a year are the offenders who are level 3s and who are no longer under supervision for their registration offense. They could be under supervision for a different offense. We don't follow that on sending. The verification letters are all triggered by that supervision for their registration offense. And then all other offenders, for example, the unassigned, the risk levels, the 1, 2s, and supervised level 3s, receive them annually. And these are mailed to their primary address. Offenders moving out of state, I just wanted to kind of bring this up so that to point or give the framework of some of our numbers too. Offenders moving out of Minnesota, the statute allows the BCA to inactivate registrants who have moved out of state, have completed a change of information form moving out of state. The Bureau will then send the verification letter to that out of state address. And upon receiving that verification letter back to the Bureau, complete with their initials and their signatures, the Bureau can inactivate that file. The registration period continues while they are gone. And they are informed in that letter that if they were to return to the state before that registration period time lapsed, that they are required to check in with local law enforcement and pick up and finish off that registration period. They're also subject to the same restarts as any other offender while they're gone if they are incarcerated or convicted of a new crime. Again, it's come up a couple of times. We have our non-compliant public website. The statute provides that the information that, or the offenders who can be posted on there must be over the age of 16, and they must be non-compliant for 30 days or longer. And the amount of information that is on this public website is limited to the information necessary for the public to assist law enforcement with locating the offender. I'd like to point out too that, and Angie brought this up as well, a little bit different than other public websites, is that offenders are automatically removed once the offender is brought into compliance. Our system is set that the minute staff here says this offender is compliant, it prompts and tells them that they have now been removed from the website. So it's instantly that they come down. This is what the public, just a screenshot of what that public website looks like. The information that you can query by on this. This is what the return looks like. And this is the amount of information. So you can see it's very limited to the demographic information about the offender, scars, marks, and tattoos, when the offender went non-compliant, and the reason for their non-compliance. The remaining part of my presentation here will just cover some statistical information of the data that we have right now. I want to point out that the data that we are going to be looking at was pulled on August 3rd of 2021, excuse me, I almost said 2021, and that as of that date, we had 18,072 registrants. Of those registrants, this is our male-female breakdown. We have 17,656 male offenders and 416 female offenders. The race of the offenders, I'm assuming everybody can see the screen, so I'm not sure that I need to walk through this or not. The unknown offenders, again, some information coming in our records are only as good as what we get when, if it's on the criminal history information, and some of these could be in the middle of being entered into. When we're grabbing live data, we grab at that moment as well. Age groups. You can see this is the breakdown of our age groups. Our youngest offender as of August 3rd was 14, and our oldest offender was 95 on that date. I'll give you just a minute and leave this up to be able to look at it. And as you can see in here, we've got 38 juvenile victims at this point. I know that was, oh, excuse me, not victims, I'm sorry, offenders. 38 juvenile offenders listed on the registry at this time. The offender residence type, this is where we have the offenders residing right now. The 37 offenders who are unknown, their last reported address to the Bureau, they're actually out in the community with the last signed to address in a secure facility. So either a prison or a jail, most likely outside of Minnesota. Because we see every one of these signed forms as a legal document, we cannot legally move them back to their previously signed to address. But we also don't want law enforcement to write them off on a suspect list if necessary, because it looked like they were in a secure facility. So those 37 offenders were last in a secure facility, but we received notification or identified that they are no longer incarcerated. Again, most of these are offenders who had signed a change of information form in a Minnesota facility, most likely going to another secure facility in another state, and therefore later on released from that state, and we don't have a form indicating where they're at. So we're actively trying to locate them at this time. Offenders by risk level. Again, as Angie had mentioned earlier, offenders, the only offenders who are assigned a risk level are those offenders who cross the threshold of the DOC's prisons, with the exception of offenders who come in through interstate compact and a couple of, in another scenario at the request of law enforcement. But I believe all of them had to have served time in a prison, kind of following those same rules as the leveled offenders that we have. So what this information here is showing you is, we've got, for those who are subject to broad notification, that level 3, I'll just kind of jump down to that group because that's the ones, those are the offenders that would be on a DOC public registrant website. Of those 1,273 offenders, 223 of them are actually, we show incarcerated right now, or as of August 3rd. 577 of those are out in, or are in MSOP treatment program. And then 33 of them are in a facility. So when we take that 1,273, you have to subtract those numbers from those that are actually posted on the public website that the DOC has there. And then I'd like to point out too that the 9,647 offenders that are unassigned, that means that they have they were assigned to supervision. They were not sentenced to prison. They haven't served time, or they're a juvenile offender as well. Juvenile offenders do not receive risk levels. So they would fall in that group as well. Yeah, and of the, thank you, Angie, for pointing out that I have the 1885 that are incarcerated. The DOC would assign those as long as their registration offense is not a juvenile offense. I'm not sure, I can't speak to the amount of time ahead of release that they have to assign a risk level, but statute 244.052 will dictate that. But those offenders, upon release, if they have an adult registration offense, would be assigned a risk level at the time of their release. Mark, I see somebody just raised their hand. Do we want to take the question now or do we wait? Or Kendra, maybe it is. I'm fine either way. This is actually, and this was my last slide as well, Mark, on the stats anyways. So if we want to go to the questions, that's fine. Kendra or Mark?
Sherry has a question, so go ahead, Sherry. Just a quick question. I was trying to clarify the data statement you made on the level 3. So of the 1273, just for those that are public on the site, you would subtract the 223, 577, and the 33 in the facility because they won't be on the site. I was trying to take a note as you said that. Could you clarify that statement again?
Yes, in this I should, this is more, that is the DOC's website, but the DOC's website does not post those that are incarcerated or in a residential or treatment facility.
Got it. So
they are not, yep, sorry about that. So they are not posted on DOC's website, and they wouldn't be posted on our public website either because they're going to be considered compliant in that facility. We do not post offenders who are in prison or MSOP on our website either.
But so that, if I'm just doing the math so that I'm clear, it's 440 people that are on the site and ISR applies to them, and that is what the DOC is working with. Is that accurate?
I can't speak to ISR or the DOC piece. So.
I can answer for that it is over 400 that are on the website, but that includes both those under supervision and those who aren't under supervision.
Thank you.
So
Thank you.
It's based on where the residence is what's excluding them from those websites.
Yep. Thank you.
You're welcome. Does anybody else have any questions? Otherwise, that's the end of my PowerPoint. And again, if you have questions, please send them to Olivia and Mark, and they can route them over to through Angie and I if we are the appropriate people to answer them. Thank you, and I look forward to being a part of this group.
Hi, Katie. I have a question.
Yep. Can you state who this is? I can't see who.
Oh, sure. My name is Stacy Bedison.
Hi, Stacy.
Hi. Going back to your slide where you had the age breakdown. Is it possible that, thank you. So as of today, we have 5 that are between the ages of 14 and 15, et cetera, et cetera. Is it possible that some of the people in the 18 to 20 age group started out as minors? Is it possible that in the 21 to 30, some of those started out as minors?
You could go back technically the 30 years that we've been in existence, and it could go back, absolutely. But that's not what this is. This is the age as of today. Yep. Or
Right.
actually as of August 3rd.
So it's possible that many of the people in these age groups started out as registrants when they were minors, correct?
I don't know that I would say many, but some of them could, yes, to answer that question.
Okay. And do we have data on that? Is there a way to track that?
The data request, that's going to have to go through Mark and Olivia, and we'll have to see what data can be pulled. That would be a question to email the group, Stacy, or the chair people, I'm sorry, or not chair, I don't know what they're called, leads, co-leads.
So Sherry is next, had a question.
It's a follow-up to exactly what Stacy said as well. I'm supremely interested in the analytics of people who move between age ranges and levels, and then year over year. I think, when you apply a kind of a loosely used the term scorecard or an analytic approach, to Stacy's point, do you navigate recidivism through data or through, how is that? Because that to me is such an important exercise. And I was curious of the very same thing, but even by county, as you start to look at it and ultimately create resource plans. Thank you.
So
Oh, I'm so sorry. We can absolutely try and figure out what data we have available. Please send us data requests via the group so that we can track them and be sure that we're actually addressing them.
I really appreciate the answer, and
yeah, of course.
Hopefully there is data there or ongoing data.
And then Nate.
Thank you, Mark. Maybe I could just do a data request. I guess my interest was more in like what, two things. I think one is, was the original offense a sex offense, or was it like an offense arising out of a different offense that was arising out of the same set of circumstances, or was it one of these offenses that's on the list that's like kidnapping or false imprisonment that's not necessarily sexually rated at all? And then the second question is, how many of these people are like within their original term, and how many have been extended?
Yeah, and unfortunately, we don't have the data available to us right now, but again, we're happy to provide any and all data that we have available in response to these requests. So if you send us the requests, we will have folks try and pull data as best as we can to answer these questions and hopefully provide a bit more of a picture to answer some of the requests.
Is that another question, Stacy?
Hi, thanks, Mark. So just a process question. Does it make sense to gather all of the data that people are interested in kind of one grouping so that we can see? So Nate has a question. Nate has questions that I had about which registrants had renewals based on another conviction, or maybe it was a failure to register, either conviction or the 5-year, for whatever reason, if they had to renew their time period. And then if it makes sense to collect these data requests in one body so we all know what we're asking.
Yep.
Yeah.
And that might be more efficient to get the data instead of just being peppered with a bunch of questions.
That's totally fair. If you send it to Mark and I, we can compile into one request.
Yeah.
Be sure to verify that with you all, and then we can go ahead and pull the data based upon that compiled request. I hope that addresses the concern, Stacy. Correct me if it doesn't.
Yeah, I think it does. And then the other follow-up to that is, I understand, having done data requests on predatory offender registry before, which you've helped me with. It would be really nice to know as soon as possible which data sets you have and which we need to go to the courts for, because I think a lot of the information that we're all curious about is within the courts. And my sense is that that's going to take some time to gather from the courts, given the state of affairs. And given the brevity of our time together, I think that we need to understand very quickly, where are we going to the courts for information so that we can do the work in 4 months?
Yes. So what I will say is that I do want to just remind folks that our predatory offender registration system is purely to track these people where they are. It is for their registration. So we might not have some of the data points that you have brought up based purely on the intention upon which that system was created. And so between ourselves and the courts, we can divvy up those questions and determine who has what. We can figure that out. Karen, I hope that's okay.
Yeah. And I gave Karen the warning that there would be requests.
Yeah, it's also in statute, so yes, but we are happy to pull what we have available to us that is available. So just know that we're happy to respond to any data requests that you have as quickly as possible based upon what's authorized. I hope that helps.
Okay. I think our next business here is to make sure we have leads in the working group. And what I would like to do at this point is if Commissioner Snell and Superintendent Evans are here to sort of lead that next part.
Well, good morning again. Let me turn my camera back on. So I think ultimately, I think the goal was to try and have the group select leads. Would be, Olivia and Mark would serve really as the liaisons from both the BCA and from the DOC, and would be the people to gather all this information and do a lot of the operational work of the group. But ultimately, we would like to have members of the group that were set up legislatively, take on the lead and the facilitators for this process, so that it's not driven by us, but driven by the working group in accordance with the law and in accordance with the interests of the group, ultimately bring back some recommendations. And so with that, I know that, you may not be thinking, am I one of these people? But I think it would be great to have two co-leads that the group itself would select and elect, and go from there. And they would serve as the chairs, co-chairs for the working group, and really have Mark and Olivia as the staff to them to make sure that this process moves forward in accordance with the requirements. And so with that, Drew, unless there's anything else you want to add, I would just turn it back to the group and really let the group go through the process of the challenging process of who is that may want to serve in this type of a role, understanding that that both agencies are fully committed to providing whatever support is necessary as we go forward. Drew, anything else?
No, Commissioner, I think you hit it well. And I think what we're just really looking for is that really, somebody, a couple people willing to step up and provide that, leadership to provide the broad spectrum and of examination of these issues. And as Commissioner Schnell said, we often view our roles as, the state agencies as carrying out the policies and that groups look to, and we don't want to see it as being driven by us in any way. We really want to make sure that that broad spectrum is represented here and led by the working group, not by us as agencies.
And we do want to make sure we introduce one more member of the working group, and that's Senator Ingebrigtsen, and you may have a question also.
Well, thank you very much. Yes, I do have a question. In my former life of 34 years, I was in law enforcement, was elected sheriff 4 times. And from that point, I jumped from, as they say, the kettle into the fire. I've been in the Senate for 15 years, and I enjoy the Judiciary Committee, working with that, obviously, that area an awful lot. So I'm very interested. My question is, and I think it's Representative Moeller, you asked me to, if I would sit on here, and I just, it sounds like it's going to be a 4-month-long process, and with everything else going on, I'm just wondering, what are the questions that we are to try and answer here? I'm somewhat interested in, of course, the juvenile offender, becoming an adult and continuously on the predatory offender list, if there is really no reason for that person to be on there. I can give you a hypothetical, I suppose. Maybe the victim and the offender end up joining up and getting married. I mean, do we continue with that kind of a thing? And I guess I'm not even familiar with that. So there's some questions that I have, but so we're looking at one month or 1 day a month to meet with this, and what do we hope to bring to the legislature? Do we know?
And I think that's a great way to start out the discussion, because for one thing, you need to select leads, and then you need to select how often you're going to meet, how how much time? I guess it's up to the group if you think you can accomplish a lot once a month, but that's one of the discussion points also. We have about a half an hour here to sort of at least get that process started and minimally pick your chairs and your next meeting. Sherry.
Again, I think what's fascinating about this is I assume everybody comes to this with a different perspective, a different area or opportunity for which their skills and ultimately reform are rooted in. And so when I thought about this, I thought, how do you combine 17, 18 people and homogenize to a degree a certain amount of platform per se, so that we can define what a win looks like coming out of this. And where 18 people could have 18 different perspectives, is it per se important for us to create some sort of an issues strategy log or before we even decide on the chairs, to determine what are the things that are of greatest importance as we think about the affect that we can have. And as we all look at the data, and this was an excellent review, getting to something that is digestible and can be impactful, probably will have an opportunity for us all to sort of lay out what are the issues that we've all isolated as important, critical, and why we're here. So is it more important that we put those on the table first, and then a chair may be more intuitive after we suggest that there are some things we may want to debate or all see in common? It's more of a question around how to begin.
Representative Moeller.
Thanks. I was looking for the language from the bill that creates this working group. I think it would be helpful to hear exactly at the legislature what we said the working group's task was. And I'm sorry, I don't have it sitting in my dining room. I thought I had it right here in front of me and I don't. So I don't know if someone can grab that quickly. And Sherry, to speak to what you said too, I think setting out some goals maybe before we have elected leaders might be useful. I'm fine doing it either way. I'll just say, as somebody who wrote the bill for this, and if someone that was on the last working group wants to speak to why we're here today, this working group was essential to the stakeholders coalition for the criminal sexual conduct reform. Many of you came and testified at the legislature. The initial bill didn't have anything about POR in it, in part because I didn't have the working group's final report when I drafted that initial bill. And at the first hearing, many of you came and testified saying that you really wanted to have some kind of reform to the registration statutes. And I know, Patty, you spoke very eloquently about the need for that and how we keep adding on over the years, and have we really taken a look to see if it's making our community safer or not, and what are some of the long-term consequences. And so when I put this POR working group into the legislation, that's what I had in mind, was the comments that the CSC working group members had relayed to me about their concerns with our current statute. At the same time, they were working on some draft language, but I understand that it might not have been fully compliant with all of those federal requirements, which are really complicated, and how those federal and state intersect, as our two presenters showed to us. So I just kind of wanted to put that out there as background as to how we came to be. And if someone has that specific language, I think that would be useful to look at.
So I can read the duties as enumerated. Is that what you'd like? Okay. The working group must examine and assess the predatory offender registration laws, including but not limited to the requirements placed on offenders, the crimes for which POR is required, the method by which POR, that is predatory offender registration, requirements are applied to offenders, and the effectiveness of the POR system in achieving its stated purpose. Governmental agencies that hold POR data shall provide the working group with public POR data upon request. The working group is encouraged to request the assistance of the state court administrator's office to obtain relevant POR data maintained by the court system. So that is the enumerated duties. Commissioner Schnell.
My question was exactly the same, was just the legislative intent relative to this, and that has been clarified. And I think even maybe looking a little bit at some of the recommendations that had come out of the working group, at least some of the discussions there might help with some of the scope around this. And I know there were a number of members who were part of that might be able to illuminate some of that.
Okay. And then Stacy.
So as someone who was on the CSE working group, also along with Nate and Jim Fleming, who I would love to hear from too, but we talked for many hours about the registry. And so there was a lot of discussion that leads into what we're doing here today. We put together, the CSE working group put together some really top issues that we as members of the CSE working group felt were really important to consider as we were revising, as we were looking at revisions to the CSE statute and broadening the criminal penalties. What we knew was the registry was going to grow. And it has grown, over the last 30 years as we've continued to add additional crimes onto it, as we add additional requirements for registrants to adhere to. And when they don't, they continue to have to, be on it if they fail to comply. So what we saw in the CSE working group was we're expanding liability. And if we're going to expand liability, we need to look at how that's going to impact the registry, since the registry really hasn't been looked at in a critical way, since in terms of its effectiveness and who's actually getting on it. It's just been added to. So we came up with 4 priorities in the CSE working group. And I hope that those priorities are carried over and discussed here, because we spent many hours thinking, well, what are the really key issues that registrants are facing? What is important to victims and survivors? How does the registry impact victims and survivors? How does it impact reporting crimes? Is it a deterrent actually for some people to report a crime if they know that the person that they may be reporting might end up on the registry for the rest of their life? And then, another key question is the registry working as intended, which is to help solve crimes? Is it helping crimes? When we look back to at the beginning, we need to know how to find a potential, a suspect. Like, we need to know who's in the area. We need to know quickly. And so is the registry actually helping crimes get solved, or is it effective at ruling out suspects? But our 4 top priorities, I'll just say them quickly, and we had draft legislation. There was a comment about the federal requirements, and I think that's a good one. We didn't do that analysis, and we need to. But the 4 top priorities were juveniles, the challenge of this similar or same set of circumstances, and what that does to people convicted of a predatory offense, or people who are required to register, because they're not always convicted of a predatory offense. They're convicted of something else, but they have to register anyway. So looking at that similar set of circumstances. Also looking at, is there a way for people to petition to come off the registry if they've been compliant? Similar to the expungement statute is where we looked. If a person is doing all the right things, is there any incentive to them? Is there any way for them to say, hey, I'm doing well, and I should have an opportunity at least to petition for relief to get off? And then the other one was looking at the penalties for failure. If there was a missed, I'm just looking at our draft language here. If there was or how long the registration period would last or be continued if there was another conviction for a non-predatory offense. So someone might have a drug charge, but then their registration requirement resets for another 10 years, and it has nothing to do with being convicted or charged with a registrable offense. So those are the 4 areas, and I will let my anyone else who was on CSE talk.
Okay, Jim, you're next.
Stacy summarized it very well. I think coming out of the work group on the criminal sexual conduct, we felt that, and this wasn't just defense attorneys, this was collectively a lot of the players in the system that said, if you're gonna sort of bring some reform to criminal sexual conduct, you had to certainly look at the POR statute and how it's applied. I don't know that in 4 months we would be able to make a determination about the effectiveness of the registry, but I do think that is a fair question that needs to be answered. I think that I just want to reiterate that there was strong feeling that we don't know why juveniles have to register, particularly given what we know about brain development, about what we've learned about recidivism rates, particularly among juveniles, why it is that we're doing this. We also learned in our research, Minnesota, and I think Angie alluded to this, Minnesota is the only state that has the same set of circumstances requirement for registration. Most all of the states, I think there may be one up, and I don't know that they actually apply this like we do, require a conviction to be on the registry. Where in Minnesota, we sort of have this administrative process going on through corrections, saying, well, this is out of the same set of circumstances, and you must register even though that person did not get convicted of a registrable offense. And prosecutors were very much in support of looking at this language and seeing if this was in fact necessary. And did this contribute to a exponential growth in the registry that may hinder its effectiveness? So that's what, I know what I'm saying is I'm reiterating essentially what Stacy said, but I think that was the thrust of the work group and some of the questions that we felt needed to be looked at. And it wasn't just defense attorneys, it was prosecutors, victims advocates. It was a fair, broad selection of people that brought these questions to light.
And then Nate.
Thanks, Mark. Yeah, one of the issues that at least I had from my perspective is the violations. And I think I brought this up at the working group, but how easy it is to violate, and then more importantly for what I do, the mandatory prison sentence that accompanies that, which as was pointed out is honored in the breach almost as often as it is. But believe me, there are plenty of people who are going to prison for at least a year and a day because that's what the law says. that it also is one of the more commonly departed offenses, and we can discuss that. We can roll out the data at a different time, but that's certainly a concern from the uniformity, proportionality aspect of the sentencing guidelines, that we have to make all of these presumptive commits under the sentencing guidelines because that's what the statute says.
So next, I'd say Commissioner Schnell and Superintendent Evans, if you see any direction that we're going.
I would just say, again, I think that those things, I think, were the framework, obviously, for this, that the impetus. I think there will be certainly other items that may be tangential to that the group may want to look at. I guess that, that really is, I think it's really the group's decision relative to how to prioritize those things. And, what's intriguing to me is I think a number of those issues are quite specific. And then, I think as Mr. Fleming just kind of pointed out, there's also this big overarching question about, is the question about, is the registry doing what it was intended to do? And how those questions get answered, I think, are the work really of the group. And so I would refer it back to the group just in terms of is this sufficient relative to the guidance, the four kind of broad areas, and what other areas members may be interested in looking at that may be tangential to that as part of the scope of the group. And then I think it is the work of the group to identify those those co-chairs to work with the two agency leads.
So we're down to 14 minutes.
So Mark, I guess one of the questions I would ask first, are there other issues that members would like to add beyond the 4 items that came out of the CSC working group? Representative Mueller, I see.
Yeah, thanks. There was a question going on in the chat about whether or not somebody who is subject to registry was on this group or not. And I think it would be useful at some point to at the very least, maybe hear from impacted persons as we're talking about future presentations.
Thank you. And I believe that is being planned, that there was having some folks come in who are on the registry or impacted by registration come in and speak with members.
Thank you.
Other areas of interest? If not, I would ask, is there someone who has an interest in serving as a co-chair, or is there someone who members think would be you would like to nominate for such a role? But certainly we would be looking for people who would have an interest in helping facilitate this, and perhaps at least someone from the working group would be helpful, because I think some of these issues and points of discussions were there. And we can certainly bring other people into the group as members. We were working on putting together this list rather quickly here. And so bringing in impacted, I know that there's some folks that have been identified through the coalitions that may or may not be on today. The MNCOS, of the Coalition Against Sexual Assault, participating. But is there someone who has an interest in serving in this role? It's a quiet group today.
Stacy.
The senator raised a really good question, and that is the frequency with which this group will come together. And I think that's something that we haven't determined. Given the short time that we have together and the big charge that we have, and that we want to, to Sherry's point, what are we going to bring to the legislature so that our time together has been worthwhile and effective, and that we get good work done. So I will say for my part, everyone, I would be willing to serve as a co-chair if the will of the group, decided that was in the interest of our work together. I guess my only asterisk on the I'm willing to serve is the frequency with which we're meeting and what that looks like in terms of time commitment.
Can I ask a question about that, Stacy? And maybe a little bit, I was not a part of the CSE working group, but it's my understanding that there were different groups that kind of broke off, and then there was some reporting, or people were doing different work at the same time. Is that accurate? Subgroups almost.
So yeah, so we had committees for the CSE working group, and the committees would do work between larger meetings. But Jim, you were on the steering committee. I think the heavy lifting really happened in the many committees we had, and Suzanne Elwell ran those committees. So I think that's where a lot of it happened. Jim?
Yeah, I mean, it was broken down in subsections so that, everybody didn't feel like they were taking a huge bite, that they could sort of focus on particular aspects of reform. And I mean, at least in the 4 areas that maybe we laid out, we could break this down, combine 2 together and have essentially 2 subcommittees meet and, try to work through this and see what we could come up with. Or we could break it down into 4 section subcommittees and see what could happen. One in juveniles, one in same set of circumstances. The other is whether or not a person, whether or not we should allow for a petition for relief to get off the registry in certain circumstances. And I think Stacy certainly alluded to what those offenses that extend registration.
So Sherry?
Yeah, I'm an advocate as well of a smaller subcommittees. I think that, and I respect the history of all the work that was done in the 4 subtopics. And again, without seeing the data, it's almost hard to analyze exactly the starting point in terms of being effective go forward. So if all of these things and the data would lead you to believe that that the juvenile, you've already determined that. So breaking it down and then evaluating the data that goes along with each of these subsets would be important, because I think when you start to look at it, there may be other work like ongoing GPS monitoring if the homeless problem is too big, or you may suggest that those that aren't leveled, tracking that is equally as important, because do they rise from non-leveled to leveled? And that's where it's hard for, pardon me, a lay person or a business person like myself to assist without understanding all of the data. So the subcommittees might be able to take on a piece of digesting that and working towards some resolution if there was more of us working on the data and evaluation based on those 4 things that Stacey read to us. So I would feel the same way. More subcommittees would be better, probably, based on time.
Thank you. Janine?
Thanks. I was just a little bit going back to the, I agree with the subcommittees as far as efficiency and length of time of the project. I was also looking at and I wasn't part of the CSC group, so I think those 4 priorities are really great. the language in the bill seems like there may be a macro component that may not be captured in the priorities of just the overall effectiveness, if you will, of the registration system. And I don't know that that may or may not need a specific committee. I'll defer to the BCA folk. If they had the numbers that would sort of be able to at least scratch that itch of the legislature in that language around requirements and how it's applied and the effectiveness of the system. So I just didn't want to lose that. There must have been some conversation somewhere that was relevant and important before we go into the weeds a little bit more of the legitimate weeds of the 4 priorities. And then I would just offer up my own wonderment around the violations that end up back into DOC. I don't know if that would be a tale to the effectiveness of the system in that folks who are getting a year and a day back in corrections because of the failure to register. So that may or may not be tagged to one of those, but I didn't want to lose that in the conversation. Thanks.
Excellent, thank you. Representative O'Neill.
Thank you. I just wanted to weigh in very quickly. Since I've been working on these sorts of issues for 9 years or so, I think that what the legislature really wants to hear is the effectiveness of the registry, the downfalls of the registry, and how large the registry has grown, over 18,000, sometimes as many as 20,000, and how that impacts both those that have to process all that information and those that are actually using the information. Is it actually effective? Is it solving crimes? Is it keeping people safe? So I think on the legislative side, that was the biggest question was, is this even effective? Are we tracking the right people? Are we leaving people out that should be tracked? Are there people in there that should not be tracked? And I think that should be the focus, is a little bit higher level, I guess. I'm not sure where those 4 points came from, and they're more in the minutia, but I think the overall point of it is to look at it with a critical eye and see the effectiveness of it, and particularly to keep other people safe.
So this is Angie Kiza speaking. I'm on Olivia Anderson's name here. I just would be willing to co-host or co-chair if that would be helpful. I think it might be helpful in the sense of getting information to the extent the group wants it or cares, which I think we should somewhat, as far as the federal requirements and just some of the, I guess, historical legal. I mean, I've been working in this area for about 22 years now, I think. So if that would be helpful, I would be willing to co-chair.
Excellent, thank you. Senator Ingebretson.
Yes, can you hear me?
Yes.
Okay. I would not want to be co-chairing. Let me make that very clear. However, I do know we do have a law enforcement official here, sheriff, who's and I know how much law enforcement utilizes these these records for reference, or if they're looking for somebody potentially, or and I can also eliminate any potential suspects. You know, I don't know if I've ever met Troy or not, but nevertheless, I would encourage him to look at possibly being a chair here, co-chairing. So now we have I guess if he accepts that, we have a 3-way. So that means we're going to have an election, I suppose. But I hope that's not the case. But nevertheless, I think law enforcement would play be a large input, and would help a lot.
So with that in mind, maybe folks, it might be easier for us to collect votes. We can send out the list of individuals who have said that they would be willing to co-chair, and folks can vote via email to Mark and I. It might be a little bit easier that way. So let me know what you guys' thoughts are on that.
Yep, and as we're reaching this end point, want to make sure that Superintendent Evans has a chance here, but The next steps, at least the next meeting or the process, we could set up a polling to see when the next meeting would be if you don't want to decide today. Superintendent Evans.
I'll be really quick. And I want to just get this in before as you embark on your work and look at this. I would ask that the group at least have a discussion, consideration, and along the lines of what Representative O'Neill and others have asked about, is that a baseline question of, effectiveness is certainly one thing to measure, but what is the purpose of the registry to begin with? And I do think it's morphed over time from what it was originally intended to be into where it is today. And I think that's a really worthwhile discussion as to what that should be. And then a very broad category that I'll put, but there's some specific things within it that I don't see really specifically represented there, is the collateral consequences. And that is related to the purpose of the registry to begin with, and what types of collateral consequences exist, related to the registry, and things from residency restrictions to job checks to checks being done through as opposed to, traditional background checks, et cetera, I think is worthwhile, because we hear about these issues on a fairly regular basis related to the registry. And again, it's your work, you make the decision. I just want to flag that as something that I certainly hear in my work as something that is a pertinent issue related to the registry.
I know we're at time here. Let me just get Neat just quickly.
Thanks, Commissioner. I was just going to nominate the two people who have expressed interest as being co-chairs, and maybe we could move on. But I guess if you want to do an email election, that's fine. But I've only heard two people, one of whom is to the senator's point, essentially a law enforcement representative working in the AG's office. So I mean, I'd be fine with Ms. Bettison and Ms. Keys, but I guess it's up to the will of the group.
Jody Peck had the opportunity to decide whether or not he would be willing to serve in that role. He was nominated, so certainly that's an option. Sherry, you had a question?
Yeah, I mean, I was equally trying to move it along a little bit, but I think again, the data set request appears to be a really important first step. And I think what was stated just a moment ago is also important, because the collateral impact from a victim perspective, it does beg the question, does it work? Is it working, and is it the right thing? Because ultimately the victim's propensity to commit a crime themselves, worst case, but more importantly, the collateral effect to girls in the form of self-harm and injury, all the things that go on for a lifetime, would want us to back this train up a little bit and say, in the end, can we stop even before the registry comes into play by evaluating the victim or supporting the victim? And I know someone I think it was Tim, said that, we look for these violations, but in the end, are we better served to stand in our state for something that looks at the support of the victim? And having been there, it has been a 13-year battle in my life. But again, I would just suggest what I have seen, and what we would suggest is that if we went back in time and looked at what happened to level 3s, are we at the root cause of this? And can we be different in this state by looking at it differently? And again, I'm not a legislator or a law enforcement person like all of you, so I respect that. But it appears as if we're solving a symptom, not a root cause.
Thank you. Mr. Fleming? Oh.
I just think that the 4 areas that we're talking about speak on a micro level about effectiveness on some level. I think that, in fairness, I didn't come on this committee with the intention of trying to get rid of the registry. I'm not saying I'm a fan of it, but I think that there are certain things going on with this thing that we really need to look at. And those four areas, I think, speak to that intention from the legislature. And honestly, 4 months isn't really a lot of time. I mean, we had over 18 months to look at the crim sex working group. And, this 4 months is, ambitious So I think if we sort of break this down into these 4 areas, we may be able to give the legislature something to consider.
Thank you. Sheriff?
I'll just say briefly, I appreciate Senator Ingebrigtsen's vote of confidence, and I'm willing to help however the committee would like.
So there is a motion. We have we had Ms. Keys and Ms. Bedison, who are both expressed interest. The sheriff is also willing. Sheriff, I'm wondering if there might be an opportunity here for some type of a team approach, or somebody suggested this as a way of looking at this, that the 3 of you develop this a leadership team around this, given the range of issues that we may have here. Is that something that you would be interested in? And I would go back then to Mr. Reitz, who had kind of made that. Is that something that you would be willing to kind of amend by way of an emotion, and we could see if there's a second and move this forward? Is Nate still on?
I just want to add that Angie said that she is totally in favor of having all 3 as leadership. Sorry, we're sharing a computer, so.
Mr. Reitz is gone, it looks like. So we have a 3-person, I guess I would just defer it back to the committee. Just, is that, by a thumbs up, whatever it may be, is that something that you can support, running these 3 people as the leadership team? And then they will work with staff and work on getting the meeting set up. I see 2 thumbs up there by Senator Ingebrigtsen, so that's good news. Stacy?
Thumbs up or the green yes.
Okay. All right. I'm going to turn it back to you, Mark. I have to jump off, but I appreciate this, and I look forward to, I'll join in as many as I can, but I'm really grateful to all of you. And I look forward to seeing the work of the committee. So thank you so much.
Okay. And if, I think probably people have to leave. So should we leave it to the 3 chairs leadership group to set up the next meeting?
Mark, why don't you and I chat, and we can reach out to the chairs and organize it for them.
Yeah. Yep. Why don't we do that? Any last comments?
Mark, I just like to say the same thing as Commissioner Snell. Thank you so much for engaging in this work, and we really appreciate you taking the time. We know your time's very important, and we appreciate you all stepping up to help with this.
The one thing I wanted to ask, can we download all the comments? A lot of people were, including from the public, were putting in some really substantive and important comments, and I want to make sure that we can track those.
We will. Okay. I see nothing else here. Do, again, email both Olivia and me if you have any additional requests, so that we can coordinate with the leadership group on the working group. And that should take care of it.
Thank you, everyone. Have a good day.
So Kendra, stay on here. So Kendra, were you able to get the names of the public attendees?
Yes,
Okay, I tried, but there were too many other things going on, so.
yeah, and I missed the beginning of the meeting for the recording.
Okay, and have you shut off the